Okay, it looks like we got people in. So we'll go ahead and get started at 6:01. So let's get the party started. Um, so anyhow, good evening, everybody. Welcome to another. I was really talking and singing and dancing, and I was really on mute. Like I was saying, let's get the party started. Okay, so I'll start again. Let's get the party started. Good evening, everybody. I'm Stephanie Williams, and I'm honored to be here to facilitate a conversation with Judge Smith in yet another episode of Family Matters with Judge Philip Smith. We welcome you this evening, and we appreciate your participation in tonight's episode as we talk about decision-making authority. But before we get into the business of making decisions, there are a couple of things we kind of want to talk about this evening. First, to get started, Judge Smith, I want to turn things over to you. I know that today is a very special day that we want to acknowledge, and I would love for you to share that with everyone with us tonight. It looks like the vast majority of people here are a part of the domestic bar here in Davidson County. So this will be something I'm sure they're excited to hear and join in with us about too.
Well, yesterday my office received a call from Stan Queller, who I see is on the call. But I believe it was today or yesterday, I can't remember, is the 1-year anniversary of the death of our good friend Bobby Jackson. And I wanted to talk about Bobby for a minute. I thought I'd let Stan and anybody else that wants to speak about Bobby talk about him. But, you know, I have to say, as a lawyer coming up, Bobby was one of my heroes. He was a great lawyer. And Bobby was so good to young lawyers. And, you know, I've had an opportunity over the years to practice with two great lawyers, Philip Robinson and Jack Norman Jr., my main two mentors. But, you know, I had cases tried cases with, you know, John Holland Sr., Mary Frances Lyle, of course, Rose, who's still around, Macklin Davis, Jim Martin, who is retiring from the bench in Williamson County. You know, just been around a lot of good lawyers over the years. And Bobby was so helpful to me coming up. And in later years, before I went to the bench, Bobby and I had the opportunity to co-counsel on some lawsuits. And I thoroughly enjoyed working with Bobby. I loved Bobby as a mediator. And, you know, the bar has really lost a legend. And I hope that one of these days, we can get the Robert L. Jackson Award recognized by the National Bar Association for the outstanding domestic relations practitioner, like they do in criminal, the Jack Norman Award. That would be so fitting for Bobby and such an honor for him. It's just, you know, I almost tear up when I think about Bobby. You know, having lunch with him, learning things. And I know Stan Queller learned a lot from Bobby. He practiced a long time with Bobby Jackson. And Stan, if you can hear me, I'm going to ask you to say a few words about Bobby. Most of the members of the bar that are on here know Bobby, knew him. Some may not, but, you know, if you don't mind, just say a few words about Bobby.
Yeah, Judge, thank you. I'm happy to. I hope y'all can hear me okay. Can y'all hear me?
Yeah.
Okay. Bobby and I practiced law together for 31 years. And like you, I had cases with Bobby before I practiced with him, practiced against him. But it was always a pleasure. Bobby was a tiger in the courtroom. And represented his clients zealously as we're supposed to, but outside of the courtroom, it was never personal. It was, and if he could help you with something, that wasn't going to hurt him or hurt his client, he was happy to do that. I mean, that was part of his, I guess, growing up. He learned that from other lawyers. You know, he practiced with his dad and other lawyers, and that's the way they did things. And hopefully Bobby taught me one or two things that I can still remember today and still use. But I miss him too, because it was always good just to knock on his door and say, hey, can I ask you a question about something? You know, we practiced law together for a long time, and, you know, we never had an argument. 31 years of practicing with somebody, you know, a lot of hours that we all put in, and we never really argued. I don't know how we did that, but we did. We figured it out. And he's missed by everybody in our office now. People still call in and say, what happened to Bobby? And anyway, like a lot of you, I miss him. It's definitely different not practicing with him. Not as much fun, because practicing law with Bobby was fun. We had a good time. We worked hard, but we had fun. And I will miss him as long as I'm doing this. But thank you for mentioning him. I appreciate it. I think those of us who all worked with him, hopefully all recognized what he meant to the domestic bar here.
Well, Stan, I'm going to tell you, it's going to tell you how old I am, but I remember when you joined Bobby's office and left Pat Flynn's office. So 31 years ago, it doesn't seem like it was that long. But
it doesn't. Pat Flynn and I still work on some cases together. He's my neighbor. He lives around the corner from me.
Yeah, Pat's a great guy and a great lawyer. Is there anybody else that would want to say something about Bobby Jackson, about, you know, their memories or, you know, whatever? But before we get to that, I do see one of my colleagues, and I'd like to, you know, invite her to introduce herself, and that's Judge Amanda McClendon. Judge McClendon, are you on the call? Can you hear me? Judge can't hear you. Can you unmute?
Can you hear me now?
You're loud and clear.
Perfect. Well, thank you so much for the shout out. I'm breaking the law driving down Ellington. I'm not hands-free, I have to admit, or else I should declare the Fifth Amendment. But I'm enjoying hearing about Bobby. Yes, as a young attorney, I had him as my adversary, and quickly learned what zealously representing your client meant. He was representing a friend of his, and I learned quite a bit. So I don't know how this conversation came up because I wasn't in the car, but I miss him too. He was such a gentleman, a great gentleman.
Well, it's the 1-year anniversary of Bobby's death.
Oh, I'm sorry to hear that. I feel for Todd and the family.
Yeah. Okay. Well, if nobody else, is there anybody else that would like to speak?
I just know that he probably mediated around 20 of my cases the last 20 years. He was very good. He made both sides feel very satisfied.
He was a great mediator. Okay, anyone else? Brenda?
Yeah, how are you?
Good. How are you doing?
I'm doing great.
Good. Did you want to
Yes,
say
I want it
something
done.
about Bobby Jackson? I
I-
know you got on late. It's the 1-year anniversary of Bobby's death.
Oh gosh, it doesn't seem like it's been that long, and then again, it seems like forever, doesn't it?
It does.
Yeah, he was a big loss.
Yes, he was.
Yeah.
At this point in time, I think we're going to get started talking about decision-making authority. Or we can talk about the court in New York and the jury that upheld New York versus Sullivan standard on libel. We could talk about that for a while, but that probably wouldn't be much fun.
Nah, that's no fun.
Nah,
Dude.
no.
We want to
All
talk
right,
about
well,
making decisions, but before we talk about making decisions in parenting plans, you've made a decision as it relates to our courts and how we're going to transition back into being fully in person. So do you want to share that with everybody that's on here?
I do. I'm a people person. I like to be around people. I feed off of that. Y'all are all my friends, and I've missed you. But now we get the report from the health department every week. Omicron is coming down in the numbers at a significant rate, so we're going to open back up on Friday the 25th. Not this Friday, but next Friday, and we will be in person then. For those of y'all that have special conditions or needs or whatever, we can certainly work around that until Omicron comes down a little bit lower. But we will be opening up, and we will be open from that point forward on all the dockets.
And now, Judge, do you plan to continue to keep our dockets staggered, our motion dockets staggered with the different times? How's that worked?
Yeah, I actually get that question a lot. I got that question today while I was on the ID docket. Now, I think we'll probably keep the staggered docket probably for good. I think it works out great. I've gotten a lot of lawyers have commented on it and they like it. It can give you an extra hour in the office. You come over and we can really take up the difficult cases at 10. And I do have to tell you, lawyers, that there is no exact science that factors into what is on a 9 o'clock docket or a 10 o'clock docket. Other than when I review the motion, I just think, we can go through this pretty quickly. And I'm wrong sometimes. And when I am, and it's apparent, I may move you to the end of the 10 o'clock docket. But we're going to keep doing that. I think that's worked out well. I think it's been well received by the bar. So that will continue indefinitely.
Okay, that sounds good. So let's jump right into this decision making. So we know this is a really, it can either be an issue that really can hold up a case or an issue that people gloss over in terms of decision making in 4 major decision making areas that the parenting plan sets forth: the non-emergency medical care, educational decisions, extracurricular activities, and religious upbringing. So before we get into kind of what you see as in terms of pros and cons to being, for joint decision making and or sole decision making for each of those areas, which ones do you find really are the most, that people are most impacted by? Which of those decision-making areas do we see maybe coming up in court a lot more, and why?
Well, the two areas that we see the most, and we see it about the same amount of time, is educational decisions and extracurricular activities. The one we see the least is religious upbringing. And, then there's, of course, non-emergency medical care. We certainly see that more than religious upbringing, but not near as often as we do educational decisions or extracurricular activities. So those are kind of the order, with the first two being, probably about the same amount.
And so what does educational decision making encompass? Some people I don't think realize how broad that can actually be.
It can be very broad. It can relate to putting a child in private school unilaterally if you've got sole decision making authority, and then of course the court has to make a decision if there's going to be an increase based on that alone. The court's got to look at, would the parties have been able to send a child to a private school financially had they lived in the same family unit. So, that's real difficult, particularly with no decision-making authority. It can be really burdensome on you and change your life if that were to happen, because you're going to have to pay your fair share of what that private school tuition would be, if in fact you and your spouse could at the when you were in an intact family unit.
Really? So what you're saying is if someone has sole decision-making authority in educational decisions, let's say mom, and mom decides to put the child in private school without any input from the dad or even over the dad's objection, that could still subject the dad to having some financial responsibility associated with that schooling if mom, I guess, could show that he has that ability to support that?
Yeah, I mean, you could have some language in the parenting plan that says, the agreement between the parties is that the child will not enter into private school, and incur tuition unless both parties agree. That will protect you. That is enforceable language. At the same time, if that language isn't there, and say it goes off on a default judgment, and mom has sole decision-making authority, then, in theory, dad could be responsible for a percentage of that, of the private school tuition.
That's good information for people to know.
And it can also affect, where the child is going to attend a public school, particularly in a shared custody arrangement where parties have equal times. Which residence is going to control the school district? They can agree, which is the best way to do it. But what if there's no agreement? So, and of course, there's probably going to be joint decision-making authority if they're sharing equal time. But these are things that people don't think about. What if you have a child with special needs that needs some sort of specialized education? Maybe the private school is not, the public school is not providing the accommodations that they need to satisfy the child's ability to learn with a disability. Maybe there's a specialized school like the Tennessee School for the Blind. If there's joint decision-making authority, hopefully the parties would agree, but maybe not. That could be a problem. Or if one side objected and it's sole decision-making authority, then the non-objecting side, if they have sole decision-making authority, can make that decision on their own.
So in the realm of educational decision-making, would tutoring maybe fall into that category?
I think it could. I think it's broad enough to cover tutoring. And there's a cost to tutoring. Mm-hmm. So absolutely, I think it would cover that. And generally when it comes to tutoring, both parties generally are in agreement about tutoring. It's the cost that comes into play.
Well, the cost or the tutor or the location, right?
That's right, location.
Transportation issues, the schedule, and all those kinds of things.
Yeah.
So
sometimes tutoring has to be done on the alternate residential parent's parenting time. Mm-hmm. And it's, if it's joint decision-making authority, it's a lot easier for that parent to buy into that rather than, trying to force that parent under a sole decision-making authority scenario. So there's a lot of different things that can come up with education. We're learning every day, absolutely, on vaccinations and claiming religious exemptions with schools. These are all things that we're addressing that we've really never had to address in any significant way in the past.
Now, you said another area that we see a lot of is where people are coming back into court because they are in conflict is the extracurricular activities. What are you seeing there?
Well, seeing a lot of activities for children loaded up that affects a parent, the alternate residential parents' parenting time. You know, children going to music lessons or things of that nature, and that's generally when we have sole decision-making authority in one parent. And the primary residential parent will just load that schedule up and expect the alternate residential parent to take the child or children to those activities. That is a big deal. Another situation is playing contact sports. One parent may not want a child to participate in contact sport, and the other parent is very adamant about being, allowing them to play, in contact sports, generally football. And we all know that that there are injuries that result from football, but it's a difficult situation where you have parents that have parenting styles so different. We just have to learn to deal with that.
Mhm. And now would a similar thought process be applied to decision making with extracurricular activities, as you just talked about with private school tuition, in that if a parent has sole decision making authority and they sign a child up for an extracurricular activity and there's a cost, let's say it's dance, which can be really expensive, or travel ball or something like that, would you?
Yeah, or cheerleading, believe me, I lived it.
Yeah.
All of that money spent for competitions that last about 2 minutes. Both my daughters participated, varsity cheerleading uniforms, all of that. Yes, I would go and I would support, but when my youngest daughter was a flyer, if y'all know what that is, I was absolutely a nervous wreck. And I'm sure staff, as a former cheerleader, know what a flyer is.
I cheered for McGavick.
And that's right. My alma mater. Yeah. Go Raiders.
I did. I cheered for McGavick. I wasn't a flyer though. But I was a base. But I cheered for McGavick. But yeah, so you would also potentially impute some financial responsibility on that other parent who did not make the decision, who did not have that decision-making authority.
Yeah, you could put that protection in. Also, you could put the protection in that if it's you don't want to, you're not going to require the alternate residential parents not going to be required to take that child to that extracurricular activity unless they have agreed to the child signing up for it. And generally, parents, want children to participate in extracurricular activities. We all know that's great, but you don't want another parent loading up your schedule and interfering with your quality parenting time. So, it's kind of something that I think parties should agree to. And if they do, then I think the alternate residential parent should be required to make sure the child is participating in the extracurricular activity. If the alternate residential parent does not have any input, then I'm not so sure that parent should be required to take the child to the extracurricular activity.
And now would a similar thought process apply to, this is a question out of our, from actually Sarah Digby, apply to tutoring, in that if one parent signed the child up for tutoring, and we know tutoring typically needs to be consistent. It shouldn't be an every other week thing. It should, be consistent, probably weekly in most cases. But if one parent signed a child up for tutoring, would the other parent that did not have that decision-making authority, did not join in that decision, be required to make the child available or take the child to tutoring on his or her parenting time?
Well, I'm going to give you a very lawyerly answer and say it depends. And what I mean by that is there another time that the child can attend tutoring? Is the primary residential parent taking the child at night after school? to tutoring, but yet scheduling the second session on the alternate residential parents time, yeah, I might have a problem with that. Again, it depends on how much time the parties, each the PRP and the ARP have. If it's close to 50-50, well, then they both need to share equally in making sure the child attends the tutor. It's in that more traditional every other weekend type of parenting arrangement that this really comes into play with, where one side has really loaded up the child's extracurricular activities on the weekend that the alternate residential parent gets the child or children.
So when cases come in front of you, and let's say they've got joint decision making for everything, and a case comes in front of you and it's like, okay, we don't agree about where the child's going to school this upcoming semester. One parent wants to homeschool the child, let's say, and the other parent, is against that and wants the child to attend regular public school or some other form of schooling. So at the point where a case comes to you and that is an issue, what do you do? Do you change decision-making authority, or do you make the decision and leave it joint going forward?
I will be honest, if I can avoid making the decision, I will. My belief is that, parents need to be parents, and courts don't need to micromanage. We have to trust parents to make the right decisions. And again, they have a constitutional right to raise their children as they see fit. Now that right is trimmed somewhat when a divorce is filed and the state intervenes in their life. But my thought is the parents need to make the decision. And that's why it's important to make sure, if it's a situation where the parties can agree, that the right party is making the decision at that point. So, I will say, and I may be jumping ahead, but in any category of decision-making authority, please, please, please don't settle the case on joint decision-making authority if your client tells you it's not going to work and you actually agree with them, because they're going to be right back in court trying to straighten it out. It's better to go ahead and adjudicate that issue on the front end than getting down the road and saying, this is a problem, and trying to adjudicate it then. Generally you have other things you can trade in a divorce case, negotiate with, even things that may be part of a marital dissolution agreement, separate and apart from a child. But don't just compromise and say, I'll let somebody else deal with it, or, I'm sure they can work it out. Go ahead and address the issue on the front end.
How do you determine, or what factors do you look at to decide who should be given the ability to make a decision in a contested issue when you're looking at changing decision-making authority?
Well, those factors are actually set forth in TCA 36.6.407C. That's, the court has to consider those four factors in deciding who is going to be granted decision-making authority. And the first one, the first factor, and I don't remember them all just like verbatim, but the first factor deals with, has there been any domestic abuse inflicted by one of the parties on the other party or someone else? And if that is an issue, if that has occurred, then it limits decision-making authority in certain categories, and well, all categories, quite frankly. If that has occurred, that is a limiting factor. The other is track record. Have the parties really shown the ability to work together? Have they provided equally for, you know, the care and support of the child, educational needs, you know, other things? There's a list of 3 or 4 or 5 things that they have in the statute. So you look at the track record. One is, what is their propensity going forward for working with the other side? Have they shown the desire and the ability to work with the other side to reach a decision that's in the best interest of the children? And I think the other one, the last one, deals with, do they live in a close enough proximity that they can make decisions quickly when they need to be made? And, you know, I think they're really getting at in that one is, you know, does the other parent live across the country? That kind of thing. I don't think they're talking about, you know, one lives in Davidson County, one lives in Wilson County. But those are the 4 factors, kind of paraphrased. We got to look at that. And you know, I think the 5th unspoken factor is common sense. As lawyers, you know, we look at things, we can kind of tell by the behavior of our clients, by the behavior of the other side. Is this going to work out? Have there been problems? Is there one party that has been a dominating member of this union? You know, is there one party that has a lot of influence over the other party, can, you know, kind of through duress influence the other's decision-making ability? So all of these things have to be considered in, you know, making a decision, in, you know, determining decision-making authority. But one thing Judge Robinson and I do is, if you have a high conflict case, if, you know, you've been up there every week and your client and the other side's been just, you know, fighting it out in the courtroom, well, that tells us joint decision-making authority is probably not going to work, particularly if those fights have been about, or the arguments have been about the children. We're not going to approve a parenting plan in that situation that gives the parties joint decision-making authority, because we understand that is going to be a problem going forward.
How do you view, or what do you think about parenting plans? And I think we're seeing them less now because you do have some very strong opinions about it. But parent plans that may have joint decision-making, but then it says that, you know, mom or dad will be the ultimate decision-making person in the event the parties are unable to make a decision after, you know, they've tried to do so.
Yeah, I mean, you know, I don't like to approve those, because that's just a way to kind of pacify the alternate residential parent. And, you know, we're using joint decision-making authority, but yet with the limiting language, it's not really joint decision-making authority. So let's kind of be honest with the clients, and if it's not going to work, you know, either litigate it, or, you know, they just need to back off of their demand for joint decision-making authority. And it does cause problem, because people do view that as, well, we got to talk about it, we got to discuss it. Well, in most of those things, it doesn't require a discussion. So, you know, it turns out to be a bigger problem in the long run than it is as far as resolving the issues the right way in the first place.
But do you expect that people at least try to talk about a decision before making it, even when someone has sole decision making? I mean, do you expect that, you know, in co-parenting, that a parent would contact the other parent and say, hey, I'm looking at doing this, here's some information, you know, let them have some input to consider? Or do you just find it okay for somebody to just, I don't have to talk to you about this, here, I just want you to know this happened today and this is what's going to happen as a result of that? You
know, in a perfect world, I would expect people to talk. however, you got to remember a parenting plan is a kind of a guideline for how the parents, co-parent together. But there's a lot of things that happen after the fact. One, maybe a child's relationship with one of the parent goes sour. Maybe one of the parents gets remarried, which is fine to do, but that step parent is exercising control in the situation. Maybe that step parent doesn't want their spouse talking to the former spouse. There's a lot of kind of moving parts in a parenting plan. And that's why, we're seeing so many modifications of parenting plans now. For the first 7 or 8 years I was on the bench, it was always just parenting time arrangements, either, one parent seeking to become the primary residential parent or schedule we were dealing with. Now, the bulk of the cases we have to decide really involve just decision-making authority. And, I don't know what the future is going to hold on that, but I do think the appellate courts need to put down some better guidelines as to what we do look at in forming our decisions regarding decision-making authority, coupled with the use of the statute. Rarely do lawyers ever argue TCA 36-407C. And, you just don't, it's just not something that parents argue. Lawyers argue.
We do have a question from Brenda Clark, and Laura Tech chimed in and said this is something she'd like to know as well. And it is, I think it's an excellent question that comes up often. How do you view pre-K as it relates to it being part of an educational decision? So normally pre-K is, the year before kindergarten, K4 they may call it. They even have K3 classes for 3-year-olds. Do you look at that as daycare, or do you look at that as schooling, wherein it becomes an educational decision?
That's a good question. And I will tell you, I generally inquire as to whether the daycare has an educational component. I love it when children start learning at a young age. And of course, even at K3, they're learning from mom and dad. They're learning from family members. They're seeing other children they play with, and they're learning. I have to say, though, it would be a situation that really depends on the facts, because a lot of the great pre-K, pre-K3, pre-K4 programs are very expensive. And it's going to depend on whether the parties can really afford it. I would probably not necessarily treat it as an educational decision, but I could see certain circumstances where I would. And that's really based on what the parties have done in the past.
Mm-hmm. Or maybe even what their thought processes were in the past, and what path they may be sending the child on, and that kind of stuff.
Yeah, no, I could see a situation. It's just not something you could put a bright line rule down and say that's just a little bit, that's more of a case by case review.
And honestly, you'd probably want to kind of consider the program too, because to be honest, I think a lot of facilities, label things as pre-K because it sounds better than daycare, right? So it makes it sound, my child's in pre-K, like the child has already started school, and maybe it's the same program, it's the same curriculum. They're just not calling it daycare anymore, because that's not, that's not what brings in the money or brings in the enrollment necessarily. Daycare, I think, is viewed so much as like babies and babysitting, and you get these pre-K programs, and that seems to be, seems to say it's more of a structured learning environment and things of this nature, when in fact that could be the same thing happening in a daycare if that makes sense. So I guess.
Well, and some of the Montessori programs really start early.
They do.
Sometimes, one parent may be against the Montessori format. One may be, in favor of it. There again, it just, on those type of decisions, they have to go on a case-by-case basis. I'm
So-
surprised I couldn't answer your question.
Yeah, well, no, that's okay. I think you gave some insight for people to consider, We got a question in advance, well, several questions in advance of the programming tonight. And certainly for any of you that are on, feel free to put questions in the chat. But I think this is a good question from a broad perspective about, how do lawyers or mediators work to get a case settled when people are really stuck on, wanting decision-making authority. One person really wants joint decision-making and the other person does not because they don't think it's going to work. And we know that, parents want to feel like they're equally involved with their children and that they are equally vested with the right to make decisions for their children and to parent. And a lot of times they find that exists if they have equal parenting time or close to it. And if they're on the same footing as decision-making authority. And so when people are trying to work to get cases resolved and that becomes an issue, how do you suggest that mediators and attorneys really deal with that dynamic of the struggle of somebody wanting equal decision or joint decision making and the other parent not, and that's holding the case up and things of that nature? Like, what advice would you give?
Well, I think in the areas of educational decisions and extracurricular activities, you could use the limiting language we talked about. But also, as a mediator, as a lawyer, representing one side or the other, look at the schedule. What is the parenting schedule? Is it a shared arrangement? Okay. Is it a more traditional every other weekend or a Thursday to Monday schedule? Does that come into play? And does the parent really, depending on the category, need more control over the decision-making process? If it's an every other weekend situation, does that alternate residential parent really need the control of joint decision-making authority over each of the categories? I think you look at it that way. I think also if it is during a divorce case, then there are other things that may be, in the process, and I'm talking about division of property and everything, maybe one party who is insisting on, making an unreasonable demand on decision-making authority. Maybe there's something they want that lawyer is willing to give up. In other words, negotiation is a good way to deal with it. But I think lawyers need to really know going in what their client's positions are regarding decision-making authority, make the mediator aware of it prior to the mediation, and kind of let the mediator form a strategy or what does the mediator think? They're going to be sitting in mediation with the parties. And if you've got one party that is completely unreasonable, explodes at every suggestion the mediator makes, well, that kind of tells you something. Mediator want to come back and say, look, I've been watching you in here. This isn't going to work out with you. Those are just tips on what to do or what to try to do. And there's no magic solution to it. But one thing I really believe in is if there is going to be a problem, address it on the front end, because it's going to be coming back.
Absolutely, it will. So COVID has definitely given the opportunity for people now to take sides, generally speaking, again, for or against vaccinations, right?
Mhm.
Vaccines and wearing masks and these types of things. And people are very strong in their position, generally speaking, one way or the other. How have you seen that come up in court? Have you been seeing cases where, parents are at odds about vaccinating their children? And how has that been handled, or how do you expect to potentially handle it in the future? In particular, I'm assuming where people have joint decision-making authority for non-emergency medical decisions, and now, they have a different thought process on that issue.
It's we have had this come up, and we're having it come up more now than a year ago. In fact, I had it just a couple of weeks ago on a case. And there's no right or wrong answer. Judge Robinson does it different than I do it. My thought is, and I will tell everybody, my wife's had a very serious bout with COVID. And that was a year ago next month. And she's still suffering from the effects of it, and will probably suffer some of those effects for the rest of her life. I am vaxxed to the max, and I'm going to buy a T-shirt that says I'm vaxxed to the max. And I'm, if I could have gotten 3 boosters when I went to get my booster, I would have gotten all 3 of them. But I can't let my personal beliefs enter into my decision-making authority. The way I look at it is, if a parent is trusted with sole decision-making authority and they object to the vaccination, I'm going to honor that. They were there to make that decision. That can be a tough decision, but I'm going to honor it. On a joint decision, I have not had to do it yet, but I might have to be a tiebreaker on that. That may be one of the decisions that I have to make. And again, that will be a case-by-case basis. If there is a good reason why a child shouldn't be vaccinated, I am going to consider that. And it's a tough decision that that judges have to make. There's just no right or wrong answer on it if there's joint decision-making authority. But on sole decision-making, I'm going to defer to that parent in making the decision.
Another question we got along these lines is, if a child has a serious health issue and is more at risk to COVID, do you consider healthcare decision-making as well as educational decision-making when looking at virtual school options or homeschooling or anything of that nature?
Of course, yeah, of course. And now we have to, I feel like every judge has to do that. If there's a special needs child, then certainly we have to consider, particularly if that child is subject to get, to acquire childhood diseases that may not be, that may not have been vaccinated for. Usually it's another issue another health issue that we have to look at. A child is handicapped, can't sit through a classroom all day, those things. But yes, no, I think we have to consider those at this point, particularly when we're making the decision who is going to be vested with not only primary residential status, but the categories on decision-making authority.
Cindy Chappell has put a question in the chat, and she says, you may see it on your screen as well, even if the parents have joint decision-making on non-emergency medical care, in some cases, the decision of whether to have the vaccine treatment or et cetera may be the decision of a mature minor. When they have joint decision-making, but one parent supports the child's choice to undertake care or not, and the other parent does not, so they're at odds as it relates to supporting the child's choice, how does the court consider the child's rights?
Well, I think you look at at the list of factors in TCA 366106. One of the factors that we have to consider is the preference of the child in a custody case. And that's, when I first started, it was 14 years old. Now the preference, they have a right to express their preference at 12 years old. I think I think I saw the term mature child. The older the child is, I think the more reasoned that choice will be. Kind of like the older the child is in making that preference, the preference is stronger for an older child than a younger child. So yeah, I think I would be much more inclined to hear the preference or the desire of the child at 15 years old than I would at 8 or 9 years old. So, but that's something I would consider. What is the child's objection, or why is the child's desire so strong to get the vaccination? So yeah, I think that's something that you just have to consider. You have to look at the age, the maturity level, and make the decision, much like you make when giving weight to the preference of a child, older versus younger.
Do you have any examples of matters that have come up as it relates to decision-making with religious upbringing?
I really have not ever had to struggle with religious upbringing decisions. Quite frankly, my thought is that should not be one of the four. That should not be a category that the court should be involved in. The parties that agree to decision-making authority, maybe they're of the same faith. That's fine. I will approve them. But if I've got to order one, if I've got to order sole or joint decision-making authority, to vest a parent with sole decision-making authority is almost like me as a judge choosing what religious faith the children are going to be brought up in. And I do believe that, the separation of church and state should be separated by a very tall wall that's absolutely impregnable. And so, yeah, I know parties usually don't. I've never had to decide an issue on that. I know there's a case out of Memphis where there was decision-making authority vested jointly, and I think the mother made a decision to have the child baptized in maybe a faith that the father objected to. She went ahead and did it over his objection, and I believe there was a contempt, maybe a criminal contempt brought against her, and I believe it was successful. So, but that's the one we have the least problems over, is religious upbringing.
Now, you've mentioned that domestic abuse, obviously is a factor the court considers and is a red flag when you're looking at joint decision-making, or even giving decision-making authority to another parent. Also, you said that when you've seen that, throughout the litigation of the case or the pendency of the case, there has been a lot of conflict and back and forth in court about different things, clearly show that two people are not, getting along very well, in particular on issues concerning the children. That's a red flag. What other things do you consider to be red flags that would cause the court concern or pause in signing off on an agreement with joint decision making or awarding it?
Well, I think getting back to the domestic violence, the issue on that is the theory behind that is the control the abuser has over the victim. And you may have a situation where there wasn't any physical abuse or domestic what would rise to the level of domestic abuse involved, but it is apparent from the testimony, as well as maybe appearances on pretrial motions, that one party is just controlling or attempting to control the other party. And we do see that on occasion. And, I will consider that. And a lot of times I see people trying to control me as the judge. And, I had that come up a couple of weeks ago or a week ago. And I told the guy, look, you're trying to control me and I'm not going to put up with it. So, that's something that I would look at. Other things, just the reasonableness of a parent's position. If it's absolutely unreasonable, then, what's causing that? Are they going to be any more reasonable when they're dealing with the other parent? So, these are things that we all have to look at and kind of determine. Now, my role obviously is a little bit different than the lawyer's role. They've got to an extent do what their client wants them to do, and zealously represent their clients within the bounds of the law. Mine is, and I say this, mine is to look at the ultimate obligation is look at the best interest of a child. And so, I can't say I always get it right, but I try. And when you're doing this every day, you do see things. And I've told lawyers this before, the worst thing, in my opinion, that can happen is to come in for a final hearing and the judge know your client almost on a first name basis.
So true. That's never a good sign.
It's not a good sign.
And it happens more than it should probably. Just say, Mr. Such and Such or Miss Such and Such now. Yeah.
Back again. Here we go.
Here we go. Good to see you again. Well, I think we're going to wrap up for now. Thank you for this evening. I just have one more question that, we talked a little bit before we logged on with everybody today, and you informed me that you missed that amazing halftime show on Sunday. And I'm just trying to figure out, what were you doing? Why would you miss something that spectacular?
I was just piddling around the house and I thought, and I'm going to tell you exactly what I told you earlier. And yes, y'all may be offended by it. But
you might not want to say it.
Let me say it, please.
This is recorded.
Huh?
This is recorded. It'll be on YouTube.
Okay, I better not say it.
Better not say that.
I was trying to get something done, and I actually missed a few minutes of the first half in doing that. So no, I didn't see the show, and but it was a great football game. It was
a wonderful game. It was a great halftime show. It was a good Sunday. So
yeah.
I love Mary J too, Laura. I love all of them that performed. It was just amazing. So anyhow, well, thank you, Judge Smith, for your time and all the information. I think this is probably really helpful to the bar and litigants, those that are tuned in with us tonight. So it will certainly be beneficial to them as they are working together and with one another in their cases going forward. So thank you. Thank you, everyone who is here tonight to join us. Please be sure to share this, let people know they can go on to the YouTube website and watch this video or any other videos that we've done so far. And we look forward to seeing you next month. We had to move the days to Tuesday, the third Tuesday of each month, because of Judge Smith's schedule at NSL right now. So we hope that's convenient for everybody, and we look forward to seeing you next month. Any final words, Judge Smith?
Look, I'm just so glad I'll be able to see the lawyers on the 25th, and it won't be just that empty courtroom that I'm looking in. But I will tell the lawyers, I'll fess up. We actually stand up in open court even when the courtroom's empty. So we're following appropriate protocols, and we may not be dressed as well as we would with lawyers there, but I am so looking forward to seeing lawyers back in the courtroom.
Yeah, it is great to see everybody. So
it is.
Well, thank you and good night.
Good night.